Your phone keeps a record of almost everywhere you've been, for months, maybe years. Not a rough guess, a detailed map of your movements sitting on a company's servers. And for a long time, the government could go get that map without ever asking a judge for a warrant. In 2018, the Supreme Court finally drew a line, and just this year, it drew that line even wider. Here's what the law actually says about who can track you, and where the line is now. You know the Fourth Amendment protects you from unreasonable searches and seizures, but it was written in 1791 for houses, papers, and pockets. The hard question of our time is simple. How does a rule about physical stuff protect a trail of digital data you didn't even know you were leaving? Start with how this even works. Every time your phone connects to a cell tower, to text, to call, to load anything, it leaves a time-stamped record of which tower, and roughly where you were. Do that all day, every day, and your carrier ends up holding a log of your movements. Lawyers call it cell site location information. Here's why that's powerful. This isn't a live tale on one afternoon. It's a record that reaches into the past. It's a time machine, pointed at any date, and it can show where you probably were. Last Tuesday, last month, last year. Almost no detective work in history could do that. Your phone does it automatically. So, can the government just ask your phone company to hand it over? For decades, the answer leaned yes, because of something called the third-party doctrine. The idea, if you voluntarily give information to someone else, a company, a bank, you've given up your privacy in it. You took the risk they'd share it. That rule came from two cases in the 1970s. In one, the court said the phone numbers you dial aren't private. The phone company already has them. In the other, it said your bank records aren't private either. You handed them to the bank. The logic, share it with someone, and the government can get it without a warrant. But apply that old rule to a smartphone, and something feels off. Yes, technically, you share your location with your carrier every second, just by keeping your phone on. So, does that mean you volunteered a minute-by-minute map of your entire life? That you took the risk of carrying a phone at all? That's the collision the court had to resolve. It came to a head in a robbery investigation. Police were chasing a string of store robberies. They suspected a man named Carpenter. Using a court order with a lower bar than a warrant, they got 127 days of his cell tower location records from his carrier, nearly 13,000 data points mapping where he'd been. That evidence helped convict him. He challenged it, and the case reached the Supreme Court. The question: is grabbing months of your location history a search, the kind that needs a warrant? In 2018, the court said yes, but it was close, 5-4. The Chief Justice wrote that tracking someone's every move this way is different in kind, not just degree. Following that much location data, he explained, is like a time machine and an ankle monitor rolled into one, and it reaches back through years the government never could have watched in real time. So the old, you shared it, you lost it, rule doesn't automatically apply. The court put it simply: a person doesn't give up all privacy just by stepping out in public. You can be seen crossing one street. That's different from the government compiling every street you've crossed for months. To get that, the court said, they generally need a warrant based on probable cause. And because that ruling comes from the Constitution, not one state's law, it's a floor under all 50 states. No state can offer you less protection than Carpenter guarantees. Some choose to offer more. But here's the part the headline skipped. Carpenter was narrow, on purpose. It said getting even 7 days of your location records was a search, but it refused to set a hard number. And it answered only the one question: historical records from your carrier. It went out of its way to say it was not deciding a whole list of other things. And that's where the fights kept happening. It didn't settle real-time tracking. Following your phone live, right now, it didn't settle short stretches, a few hours instead of months. And it didn't touch newer technology or location data held by companies other than your carrier. The court drew one line and left the rest for another day. That another day would take years to arrive. This wasn't the first time the court wrestled with tracking. About 6 years before Carpenter, police stuck a GPS tracker on a suspect's car and followed him for a month. The court said that was a search, mainly because physically attaching the device to his car was a trespass. but several justices went further in a separate opinion, warning that long-term monitoring by any method invades a reasonable expectation of privacy. Go back further, and the whole idea traces to a 1967 case. Agents had bugged the outside of a public phone booth to listen in. The court ruled the Fourth Amendment protects people, not places. And one justice's famous companion opinion added the test we still use. Privacy is about what you reasonably expect to keep private. That's the seed Carpenter grew from. Now here's where it gets uncomfortable and very current. Carpenter says the government usually needs a warrant to demand your location from a carrier. But what if it just buys it instead? Your location doesn't only live with your phone company. Weather apps, games, shopping apps. Many quietly collect where you are and sell it to data brokers. And according to a federal watchdog report, agencies including Homeland Security and Immigration Enforcement have simply purchased that data on the open market, arguing that if it's for sale, no warrant is needed. Think about what that means. A rule meant to require a warrant can be sidestepped by pulling out a credit card instead of a court order. Whether that loophole is legal is being fought over right now, in courts and in Congress. It is not settled. Here's another new frontier: the Geofence warrant. Instead of naming a suspect, police draw a box on a map and a stretch of time, then ask a tech company for every device that was inside it. That can sweep in dozens of innocent people who just happened to be nearby. For years, lower courts couldn't agree on whether geofence warrants were even legal. One federal appeals court called them modern-day general warrants, the very thing the Fourth Amendment was written to forbid. Another let the evidence stand. Then, just recently, the Supreme Court stepped in to settle the biggest question. The case was Chatrie versus United States, decided in 2026. In a 6-3 ruling, the court took Carpenter's logic and stretched it further. Getting a person's location data, even from a company like Google, even for a short window, even though a third party is holding it, is a Fourth Amendment search. In plain English, you don't give up your privacy and where you've been just because some app company is the one holding the record. But even that ruling didn't end the fight. The court sent the case back down to decide whether that specific geofence warrant was drawn narrowly enough. So exactly how these warrants must be written is still being worked out. And it pointedly did not close the data broker loophole or settle fast-moving real-time tracking, where, in a true emergency like a missing child, the usual warrant rule can already bend. So, what's actually tracking you? Your carrier through the towers, your phone's operating system, and a long list of apps you gave permission, often without reading it, which is exactly why your settings matter. You can limit which apps see your location and turn off your location history. It won't stop a lawful, warranted search, but it shrinks how much of your life is sitting on a server waiting to be asked for. So, what happens if the government gets your location illegally? No warrant, no real exception. Usually that evidence gets thrown out. It's the exclusionary rule. Break the rules to get it, and prosecutors generally can't use it. That's the pressure that keeps the warrant requirement real. There's one big catch, though. If police relied in good faith on a warrant a court only later doubts, the evidence can still come in. That's actually why Chatrie himself lost, even as his case made new law for everyone else. Step back, and here's the whole point. The Fourth Amendment was never really about criminals. It's about everyone. It's the line that says the government generally needs real cause, not just a hunch, before it can rewind your life. Every place you've been, every person you visited. And notice how this connects. The court protected the contents of your phone from a warrantless search. It protected the map of where that phone has been. The through line is the same. A device in your pocket now holds the kind of detail that used to require following you for years. So the law is slowly extending the old shield to cover it. Here's the honest state of the law. Long-term history from your carrier. And now, geofence data pulled from a tech company. The court has said both need a warrant. But buying your location from a data broker or tracking you in real time, those are the loopholes still open and still being fought over. So here's the bottom line. In 2018, the court said you don't surrender your whole life just by carrying a phone. And in 2026, it went further, covering the newer tracking too. But the technology keeps racing ahead. Brokers, real-time tools. And the law is still catching up, one case at a time. If you remember nothing else, remember this. Your movements are more trackable than you think, and the rules are still being written. A warrant is the default for the long history. Everything newer is contested. Check your app permissions. Know that public no longer means unprotected. That's the law on tracking your location, the line the court drew, and all the places it's still being tested. Know your default, know your rights. Now you know.